Barbara Whitfield stood in her kitchen in Marietta, Georgia, holding a cup of coffee that had gone cold an hour ago. She was 71 years old, a retired elementary school teacher, 29 years in the same district. Her husband Ray had passed 18 months earlier, heart failure, 63 days in and out of hospitals before the end. The house behind her, a modest 3-bedroom on Cobb Parkway with a wraparound porch Ray built himself in 1998, was paid off, fully, $340,000 on the county tax rolls. It was supposed to go to her daughter, Melissa, and her 2 grandsons. Barbara had spent 4 years in a memory care facility after a stroke left her unable to live alone. Medicaid covered it, $9,200 a month. She never once thought about what that meant for the house. Then, 3 weeks after her funeral, Melissa opened an envelope from the Georgia Department of Community Health. It wasn't a condolence letter. It was a bill for $187,000. Melissa read it twice. Sure, it was a mistake. It wasn't. Today we're talking about something almost nobody explains before it happens. The Medicaid rule that lets a state come after your home, after you're gone. It's called estate recovery, and most families have never heard the term until a letter like Melissa's shows up in their mailbox. Here's the strange part. This isn't some obscure loophole. It's federal law, on the books since 1993. Every single state has to do it, and yet survey after survey shows most Americans over 60 have no idea it exists. By the end of this video, you'll understand exactly how estate recovery works, who it applies to, which states hit the hardest, and most importantly, what legal, completely legitimate steps families use to protect a home before it's too late. If you've got a parent, a spouse, or you yourself are thinking about long-term care down the road, this is 12 minutes you'll want to watch all the way through. And if you find this helpful, hit subscribe. We cover exactly this kind of retirement blind spot every week. Here's what most people believe. My house is protected. Medicaid doesn't count it against me. I checked. And technically, that's true. When you apply for Medicaid, your primary home is generally an exempt asset. It doesn't count toward the asset limit that determines whether you qualify. Millions of people confirm this with a caseworker, breathe a sigh of relief, and move on. That's exactly where the misunderstanding begins. Exempt during your life is not the same as protected after your death. Once a Medicaid enrollee who is 55 or older dies, states are required to seek recovery of payments from that person's estate, specifically for nursing facility care, home and community-based services, and related hospital and prescription costs. The house was never off limits. It was just off limits while you were alive. Almost nobody sees this coming because caseworkers focus on eligibility, not what happens decades later. Elder law attorneys will tell you the exemption conversation and the estate recovery conversation almost never happen in the same meeting. Families walk away with half the picture. But here's what surprises most people even more. This isn't just about the home passing through a will. In many states, recovery can reach property that never goes through probate at all. Jointly held property, living trusts, even payable on death accounts. About 27 states have expanded their recovery programs this way, while others can only reach assets that pass through the probate estate. So the plan you think protects your family, the one your neighbor swears worked for their parents, might not work the same way in your state. It gets worse before it gets better. Let's talk about what actually happens. Here's the plain English version. The rule dates back to the 1993 Omnibus Budget Reconciliation Act, which requires every state to seek reimbursement of long-term care costs through a Medicaid Estate Recovery program for people 55 and older who received long-term care services, and for anyone under 55 who's permanently institutionalized. Two things matter enormously here, and they're the two things almost nobody explains clearly. First, Medicaid does not take your home while you're alive. Recovery only happens after death, through the probate or estate process. Nobody is showing up with a moving truck while you're living there. Second, there are federal protections that block recovery entirely. States may not recover from the estate of a deceased Medicaid enrollee who is survived by a spouse, a child under 21, or a blind or disabled child of any age. So if Barbara's husband Ray had still been alive when she passed, the state legally could not have touched the house. Full stop. Now let's talk numbers, because they matter. In 2026, the home equity exemption limit for Medicaid eligibility is $713,000 in most states, though some states allow up to $1,069,000, and California has no home equity limit at all. That's the eligibility side, how much home equity you can have and still qualify. Estate recovery is a separate question. Once you die, if you're not protected by one of the exemptions above, the state can file a claim against your estate for whatever it paid, nursing home costs, home health aides, related hospital bills, up to the value of what's left. And it's not limited to the house. An estate can include cash, savings, stocks, vehicles, and other assets. But for most families, the home ends up being the last significant asset standing when the state comes to collect. There's also a timeline piece almost nobody talks about. Under a law called TEFRA, states have had the option since 1982 to place liens on a Medicaid recipient's home while they're still alive, specifically to stop last-minute transfers designed to dodge recovery. And any transfer of the home for less than fair market value within 60 months of applying for Medicaid can trigger a penalty period, meaning the family pays out of pocket for care during that window instead. That's the trap. You can't just deed the house to your kids the week before you apply. The look-back period exists specifically to catch that. Here's where everything changes for most families, though. Hardship waivers. States must allow families to apply for a waiver when a state recovery would create an undue hardship, though each state defines hardship differently and sets its own process for requesting it. That waiver is exactly what Melissa didn't know existed. Let's walk through 3 different families, 3 different outcomes. Scenario 1. The Whitfields, Georgia. Barbara's husband died before her. No surviving spouse. Her daughter Melissa was 41, well over the age 21 protection. No disabled children in the family. None of the mandatory federal exemptions applied. The state's claim was legitimate under the law. But Melissa didn't know she could request a hardship waiver. And by the time she consulted an elder law attorney, the response window from the state's notice had nearly closed. She ultimately negotiated the claim down, but the family still lost roughly $110,000 in home equity they expected to inherit. What could have been different? A Lady Bird deed or an irrevocable trust set up years earlier, while Ray was alive, could have moved the home outside Barbara's probate estate entirely, legally, without triggering a penalty, because it would have been done well outside the 60-month look-back window. Scenario 2. The Alvarez family, Wisconsin. Same situation, a parent in long-term care funded by Medicaid. But this time, the surviving spouse, Rosa, was still living in the home when her husband passed. Because a spouse was still residing there, the state could not initiate a state recovery. Full stop. Rosa kept the house. The exemption held automatically. No trust, no legal maneuvering, no attorney fees. Just the built-in federal protection doing exactly what it's designed to do. Scenario 3. The Chen family, California. Here's where planning made all the difference. The Chens knew 5 years before their father needed care that long-term care was likely in his future given his early-stage Parkinson's diagnosis. They worked with an elder law attorney to place the home into an irrevocable trust. Because it was done 5 years, 60 months, before he ever applied for Medicaid, there was no penalty period, no disqualification, no look-back violation. When he eventually needed nursing home care and Medicaid began paying, the home was no longer legally his. It belonged to the trust. When he passed, there was nothing in his name for the state to recover against. The difference between the Whitfields and the Chens wasn't luck. It was 5 years of advanced planning. So what should you actually do with this information? First, don't panic and don't make any sudden transfers. Giving away your house this year to avoid Medicaid next year can backfire badly because of the 60-month look-back rule. Rushed moves often cause more financial damage than doing nothing at all. Second, find out whether your state has expanded or probate-only estate recovery, and whether it defines hardship waivers narrowly or broadly. This genuinely varies enormously state to state, and general internet advice, including this video, cannot tell you your specific state's rules with certainty. Third, if long-term care feels like it could be 5 or more years away for you or a parent, that's the window to talk to a certified elder law attorney about tools like irrevocable trusts, Lady Bird deeds where your state allows them, and proper beneficiary designations. Fourth, if a loved one has already passed and a recovery notice has arrived, don't ignore it, and don't assume the number on the letter is final. Hardship waivers exist. Negotiated settlements happen, but the response windows are often short, so move quickly. This video is educational, not legal advice. Estate recovery law is genuinely different in every state, and a licensed elder law attorney in your state is the only person who can tell you what applies to your specific situation. Melissa Whitfield still has the porch her father built. After 8 months of negotiating with the state and working with an attorney her aunt recommended, the claim was reduced. Not eliminated. The law doesn't allow that once the exemptions don't apply, but reduced enough that she could keep the house by paying the difference over time. She still cries, sometimes thinking about the version of this story where her parents had spent one afternoon, years earlier, sitting across from an elder law attorney instead of assuming the house was simply automatically theirs to pass down. I thought paid off meant safe, she said. Nobody tells you there's a difference. That's the lesson underneath all of this. A home you own outright can still be at risk, not while you're alive, but in the quiet aftermath, when grief is already doing enough damage on its own. The families who protect what they've built aren't the wealthiest ones. They're the ones who found out how the rule works before they needed to. If this video gave you something to bring bring up at your next family dinner, or something to ask an attorney about. That's exactly what it was made for. Subscribe if you want more of these conversations, the ones nobody has until it's too late to plan for them.